Good evening and welcome on behalf of Toro Law Center and the Black Law Students Association. It is a pleasure to welcome everybody to our 2015 Jurist in Residence program. I'd like to acknowledge Dean Rafel and Dean Glickstein, and thank you for being here. Many members of the faculty are here. Elaine Gross, Executive Director of Erase Racism, and thank you students for coming to what I think is going to be an outstanding discussion this evening. We are delighted and honored to welcome Solomon Oliver Jr., Chief Judge of the U.S. District Court for the Northern District of Ohio. Judge Oliver is a fitting addition to the roster of our previous Distinguished Jurist in Residence honorees, which includes United States Supreme Court Justices Ruth Bader Ginsburg and Anton Scalia, Chief Judge Judith Kaye of the New York Court of Appeals, the Right Honorable Lord Wolfe of Barnes, the Lord Chief Justice of England and Wales, and Justice Gabriel Bach of the Israeli Supreme Court. He belongs with this group not only because of his extraordinary service and leadership on the federal bench, but for several other reasons that, well, distinguish him from his illustrious predecessors. First, he's one of us, still a law professor at heart, who remains committed to stewardship of legal education. He was on the faculty at Cleveland Marshall College of Law of Cleveland State University, serving as Associate Dean of Faculty and Administration when he was named to the District Court bench by President Bill Clinton in 1994. And despite the demands of his judicial duties, he has remained deeply involved in legal education. Judge Oliver recently completed a term as chair of the American Bar Association's Council of the Section on Legal Education and Admissions to the Bar, the group responsible for the standards and rules of procedure for approval of law schools. During Judge Oliver's term, the council completed a comprehensive review of the standards to reflect dramatic changes underway in legal education. Second, this honor is appropriate because during this month, we celebrate the contributions of African Americans to our culture. Judge Oliver is a living connection to one of the legendary pioneers of American jurisprudence. Judge Oliver's first legal job was clerking at the U.S. Third Circuit Court of Appeals for William Hastie, the first African American to serve as a federal judge, first at the trial level and appellate level. And in fact, there's a nice bio in the elevators today about Judge Hastie. And third, the arc of Judge Oliver's life represents an extraordinary American journey, one that mirrors our experience as a nation. He grew up in Bessemer, a small town outside of Birmingham, Alabama, the fourth of 10 children of Reverend Solomon Oliver Sr., a steelworker turned Baptist minister, and Willie Lee Oliver, a homemaker. Although neither of his parents, their brothers or sisters, had the opportunity to attend college, Judge Oliver's parents taught their children crucial life lessons. Remarking on how his parents have been the strongest influence in his life, Judge Oliver noted, quote, "They taught me to have a positive self-concept, respect others, stand up for what I believe in, and that if I worked hard, it would ultimately pay off." The 1950s and 60s were a time of segregation, repression, and unrest. Blacks could not take jobs as bus drivers or even store clerks. Working in a government job was unthinkable. In 1963, the same year as the Birmingham church bombing, he was traveling through rural Georgia to a church convention with 2 deacons. When he tried to use a gas station restroom, he was attacked by the white attendant, who was convinced that the trio had been sent by Attorney General Robert Kennedy to integrate the facility. Judge Oliver took note, figuring that if the Attorney General could strike such fear in people's hearts, then being a lawyer was a pretty good idea. Nearly 50 years later, after work as a federal prosecutor, law professor, and more than 2 decades on the bench, he reflected on the lessons of this turning point in his life. Quote, "Repression is a teacher. The question is, what is your response? Do you grow to hate your oppressors or grow to hate yourself? For me, the answer was neither. My parents taught me that people like this aren't monsters or less than human beings, but simply people who are misguided. And this lesson I've carried with me for life." In reading about Judge Oliver, a word that repeats often is respect. In a 2010 interview, he summed up his philosophy. This is a quote, "I don't think of a judge as being who I am, it's what I do. If people I respect believed I saw myself as being a better human being with higher status because I was a judge, that would be upsetting to me. I'd be very disappointed and upset with myself. My whole approach involves remembering who I am, where I came from, and the values that I learned from my parents, and carrying those forward in everything I do." So we are thrilled to have with us this evening this living example that with family, faith, determination, and yes, respect, change will happen. We look forward to the wisdom of Judge Solomon Oliver.
Good afternoon. Dean Salkin gave my speech. Thank you, Dean, for that wonderful introduction. And thank you for your kind invitation to visit Toro, this wonderful institution. It's an honor for me to be here, it really is. I've already enjoyed immensely the time that I spent on Professor Kaufman's constitutional law class this morning. She called on me. I hope that my answers were sufficient. Took me back thinking about my first year in law school. I see some of my classmates may be coming in from law school. Back in 1972, we were graduates of NYU. Also, I enjoyed the class of health law taught by Professor Kennedy. Had a chance to have a good exchange with her and her students about a number of topics. It's just great to be here. I enjoy the work I do as a judge. You must know that. I have to, however, help people solve or resolve some of the most important problems in their life, and that brings a certain amount of tension. But being here with you, coming to interact with you, does not involve that kind of tension. It really is enjoyable. I enjoyed the trial practice class that I was part of this afternoon. I enjoyed working with Adjunct Professor Conkin. He was filling in for one of the other professors who had to be away. I was there about an hour, had a chance to interact with the students, to do a little bit of critique, and to kind of remember what it was like to teach, or at least try to teach. I was a professor for about 12 years. And indeed, I did teach trial advocacy back at that time. I am especially glad that I'm here during Black History Month. Back at the time when I was a child, we celebrated Negro History Week. So we were called Negroes at that time, of course, and it was only 1 week. But boy, that was an enjoyable week for us all as we celebrated our history. Many of you know that Black History Week was the brainchild of Dr. Carter G. Woodson, an African-American historian and founder of the Association for the Study of African-American Life and History. He also founded the Journal of Negro History. He first announced the celebration of Negro History Week in 1926. It was to occur annually in February to coincide with the celebration of the birthdays of Abraham Lincoln and Frederick Douglass. Woodson's own story is remarkable. Born in 1875, Woodson was the son of former slaves. He worked to earn a living as a coal miner. Then he went back to school, entering high school at the age of 20. Entering high school at the age of 20, he received his diploma in less than 2 years. Thereafter, he received his bachelor's degree from Berea College in Kentucky, a master's degree from the University of Chicago, and a PhD degree in history from Harvard. Can you imagine? He served as Dean of the College of Arts and Sciences at Howard and academic dean at what would become West Virginia University. Dr. Woodson devoted his entire life to preserving and celebrating the history of African Americans. This devotion was spurred by the fact that the contributions of Black were, in his words, overlooked, ignored, even suppressed by writers of history textbooks and by teachers who used them. This had two negative consequences. The first was the perpetuation of a self-image by blacks that they were inferior. Dr. Woodson once said, if you can make a man believe that he's inferior, you don't have to compel him to seek an inferior status. He will do so without being told. And if you can make a man believe that he's justly an outcast, you don't have to order him to the back door. He will go to the back door on his own. And if there is no back door, the very nature of the man will demand that you build one. Now, the second result of black history being ignored is the perpetuation of racial prejudice in whites, which Woodson concluded is merely the logical result of tradition, the inevitable outcome of thorough instruction to the effect that the Negro has never contributed anything to the progress of mankind. And so Woodson believed that education and increasing social and professional contacts among blacks and whites would reduce racism. So one of the ways that Dr. Woodson sought to address the negative and societal consequences of blacks and their self-image was through the Black History Week, as I indicated. As I said before, that was a time when we really enjoyed hearing about our ancestors. And so we heard about Harriet Tubman, for example, an abolitionist and leader of the Underground Railroad, and Frederick Douglass, an escaped slave, abolitionist, orator, and suffragist, and Booker T. Washington, ex-slave educator, president of Tuskegee Institute, and a person who researched alternative crops to cotton, and W.E.B. Du Bois, and of course, Jesse Owens. We all know of Jesse Owens. He was born in Oakville, Alabama. He was an Olympian who won 4 gold medals in 1936 in the face of Hitler's promotion of Aryan racial superiority. He did that in Germany. Joe Louis, the heavyweight champion of the world, he was born in Lafayette, Alabama. Mary McLeod Bethune, an educator, advisor to President Franklin Roosevelt. And Jackie Robinson, of course, who came to be the first African-American in baseball in 1947. And Willie Mays. Willie Mays went to the major leagues in 1951. He grew up about 8 miles from where I grew up. And Ralph Bunche, the PhD political scientist, who won a Nobel Peace Prize for mediation of the Arab-Israeli conflict in Palestine in 1947 and thereafter. And so those are the people, some of the people that we would hear about in terms of their accomplishments. And we were encouraged to dream big and to believe that we too could accomplish despite all of the obstacles that we faced. And now let me tell you a little bit about the obstacles we faced. The dean gave you some of my background, and I think it's important to an understanding of the topic that I'm going to talk about today, and it's the legacy of the African-American lawyer and the quest for equality. I grew up, as she said, with my 5 brothers and 4 sisters in the segregated South in a small town outside of Birmingham called Bessemer. I've often joked that when you grow up in a house with 11 other people, you quickly learn how to multiply and divide. If there are 12 donuts, you quickly learn, sometimes the hard way, that your share is 1. While we were growing up in Alabama, whites lived very close to us. Their backyard was right behind our backyard. Our backyards met. Indeed, they had no worries. They had their schools, and we had ours. They had no concern about job competition from us. We could have no job they wanted. If we were lucky, we might work as a stock boy, but not at the cash register in the grocery store or as a salesperson in a department store. Blacks, as the dean said, could not serve as bus drivers or police officers or other than in the lowest paying jobs in the steel mills. Everything was segregated, top to bottom. Now, I know some of you have heard, all of you heard about this from a historical standpoint, but I think it's important to remember. This wasn't that long ago, but it was just that way. There were no blacks serving in local government. Doctors' offices were segregated. When there was a side for blacks, there would be one side for blacks and another for whites. Restrooms, as you know, and water fountains were segregated. Blacks were segregated from whites on trains and other forms of public transportation, and on buses and so forth, where blacks had to sit, as you know, in the back. We all aware of Rosa Parks, the fact that she chose on a given day not to move. So let me just say, even insane asylums were segregated. Of course, you would expect nothing less, since every other institution was. And it didn't exist just as a matter of custom. As many of you know, and I talked to Dean Glickstein a little while ago, and certainly he knows, it was not just a matter of custom. It existed as a matter of law. And racial intermarriage was strictly prohibited. Now, I've talked about the fact that we grew up knowing about our heritage, knowing about some of our heroes and so forth. And most of that was during elementary school that I was talking about, and then junior high school. Of course, as we moved into high school, we had firsthand examples of the courage of black people and some of our leaders, because I grew up in Birmingham, and you know that that was a place where many of the major campaigns were undertaken in regard to civil rights. And so in 1963, when I would have been a junior in high school, that was a year that the spotlight shined on Birmingham, because in April that year, Dr. Martin Luther King, Dr. Reverend Ralph Abernathy, Dr. Reverend Fred Shuttleworth began the so-called Birmingham Campaign. And it was a nonviolent campaign of marches and sit-ins against racism and segregation. And those leaders were jailed on April 12th, and they were jailed after they refused to discontinue those activities. So most of us are familiar with the letter, King's letter from the Birmingham jail. He wrote that letter after he was challenged by white clergymen who said, you know, why are you pushing ahead like this? Why are you doing this? Why can't you wait? And so his letter was in response, why we can't wait. And that's what the letter he wrote from the Birmingham jail. And I'll just read very briefly an excerpt from the letter. He says, when you have seen vicious mobs lynch your mothers and fathers at will and drown your sisters and brothers at whim, when you have seen hate-filled policemen curse, kick, brutalize, and even kill your black brothers and sisters with impunity, when you see the vast majority of 20 million brothers smothering in an airtight cage of poverty in the midst of an affluent society, when you suddenly find your tongue twisted and your speech stammering as you seek to explain to your 6-year-old daughter why she can't go to the public amusement park that has just been advertised on television, and see tears welling up in her little eyes when she's told that Funtown is closed to colored children, and see the depressing clouds of inferiority begin to form in her little mental sky, and see her begin to distort her little personality by unconsciously developing a bitterness toward white people. And then, skipping on down, he says, when your first name becomes nigger and your middle name becomes boy, however old you are, and your last name becomes John, and when your wife and mothers are never given the respected title Mrs., when you're harried by day and hunted by night by the fact that you are a Negro, living constantly at tiptoe stance, never quite knowing what to expect next, and plagued with inner fears and outer resentments, when you are forever fighting a degenerating sense of nobodiness, then you will understand why we find it difficult to wait. So I was in Birmingham then, and I was in Birmingham that same May when Bull Connor turned the police dogs on the children in the freedom marches. I think you're all familiar with that. He was the police chief there. And then that was the same year that Governor George Wallace stood in the schoolhouse door at the University of Alabama to try to prohibit James Hood and Vivian Malone, who were about to integrate that institution. And fortunately, the Deputy Attorney General of the United States was there, and on orders of the President, federalized the National Guard, the Alabama National Guard, and caused the governor to step aside. Now, the governor stood in that door in fulfillment of a promise he made after his landslide victory in 1962. In '62, he stood on the gold star marking the spot where nearly 102 years earlier, Jefferson Davis was sworn in as the President of the Confederate States of America. And Wallace stated on that occasion in 1962, "In the name of the greatest people that have ever trod the earth, I draw the line in the dust and toss the gauntlet before the feet of tyranny. And I say, segregation now, segregation tomorrow, segregation forever." Now, Wallace wasn't alone, and Alabama wasn't the only place that had these kinds of issues. But I want you to know the context in which I grew up. Wallace's tone really harkened back to that of an early era when former governor and late senator of South Carolina, Strom Thurmond, who was the presidential candidate of the Dixiecrat Party in '48, stated, and this is what Strom Thurmond stated: "All the laws of Washington, all the bayonets of the Army cannot force the Negro into our homes, into our schools, our churches, our places of recreation and amusement." And then, in September of 1983, 4 black girls were killed when the 16th Street Baptist Church was bombed. Now, I don't mean to talk all sad stuff, and I don't mean to spend the whole talk on this kind of history. But it's important to understand that this was not long ago. This is the context in which I lived and which I grew up. And as the dean said, I had an experience myself. Fortunately, I was not seriously hurt. Going to that church convention that she mentioned with 2 deacons, trying to go to the one restroom at that gas station, and was essentially pummeled by a person who really felt that we were there to integrate the South. That was my personal experience, but I do say honestly that I was not at all, as I said before, seriously hurt. Let me just say, I say all of what I've said as background to the fact that as I learned about black heroes, some of the ones that I mentioned, and as I learned about other black heroes as the civil rights era unfolded, I did not learn about black lawyers and their involvement in that struggle. And that's the point I wanted to make as I talk just a little bit about those black lawyers and how they were involved and the legacy left by those black lawyers, and then conclude with a few thoughts. I now know, I did not know then, that there was a band of lawyers starting in early 1900s who were dedicated to the eradication of legal segregation in America and to what the late Chief Judge William Hastie of the U.S. Third Circuit called an equalitarian legal order. Now, I clerked for Hastie, as the dean said, and Hastie was obviously not the only one. I mentioned Hastie because I did clerk for him. There was a lawyer named Charles Hamilton Houston, who was probably the leader, if you had to say who the leader was, of the group of lawyers who were involved in that period, fashioning the strategy for attacking segregation. Houston was from D.C. like Hastie, went to segregated Dunbar High School in D.C., went from there to Amherst College. He was Phi Beta Kappa at Amherst College, Harvard Law School. He was on the Law Review. He got a JSD, Doctor of Juridical Science from Harvard, but he also had a very bitter experience in World War I, and so that was part of what drove him and made him such a hard fighter in regard to segregation, one of the things. So he, that is Houston and Hastie, used the NAACP and Howard Law School as a basis for an all-out attack on the then existing racist legal order. Now, there were a number of black lawyers used in the attack, but by no means were they all black lawyers. Figuring prominently in the strategy was Nathan Marigold, a Jewish American who was retained by the NAACP in the 1930s. to do a comprehensive study, the legal status of the Negro, and possible legal strategies for constructive change. And so once that blueprint was developed, or at least plan was developed, the NAACP, but mainly Houston, Hasty, and others, began to move forward to execute that plan. They argued in a wide range of areas because racism was everywhere. And they were living in an area separate but equal, and one which didn't look like it would change anytime soon. So one area, for example, was schemes which were designed to deprive blacks of the right to vote. First, this was done by so-called grandfather clauses. Some of you may have heard of these. And then they turned to white primaries, and thereafter poll taxes. Now, the grandfather clause was utilized in the 19th century to impose new literacy and property requirements on voting, while exempting those whose ancestors, grandfathers, had the right to vote before the Civil War. So essentially it would freeze voting so that only whites would have it, with very few blacks. And they had to go to the Supreme Court and fight that. Having won that battle, then they began to have to deal with so-called white primaries. And that sounds preposterous today, but the argument was that that was not the final election. They were private parties, and therefore they didn't have to allow blacks to be part of it. Most of the South, of course, there was only one party, and if you won the party election, that was the end of it. So they were able to strike that down. And then the poll tax was next. And the poll tax was not stricken down until 1966. I don't know how many of you saw Selma, the movie, but if you saw it, it was a scene where a woman was in who was obviously very prepared to go ahead and become a voter. And question after question, he would pose to her about the preamble to the Constitution. And she would cite the preamble to the Constitution. And they would ask some other question of her. And finally, they asked her some question, I think having to do with how many counties did they have judicial officers, or some strange question like that. And of course, she couldn't answer that question. And that was sufficient to prohibit her from voting. Well, it was that kind of thing that was being carried on throughout the South. Now, then once they fought, and I won't obviously go into the details of that, but once they fought battles, and every time there was another obstacle, they would take that on and so forth. Another one was in regard to restrictive covenants. So it was, you may have heard about this in constitutional law, or maybe you haven't, or in property, but there was a time when whites would, in a community, say, I will make an agreement with other people who live in the community that I will only sell to white people, will not consider anything from blacks. And so they would have these restrictive covenants. And so if a white person wanted to sell, then of course they would be confronted by their neighbors and obviously could be sued in regard to that. And so they fought restrictive covenants, always the Supreme Court, until 1948, the Supreme Court struck that down. Let me just give you a sense of how deeply embedded racism is and was in that area and in that era. So this is a case involving a restrictive covenant. And the question is asked of Ms. Hodge, who's on the stand, a white woman. Now suppose, Ms. Hodge, it was a very, very light Negro, say 99% so-called white blood. Her answer, it would still be a Negro, I think. Question, and would it not make any difference? Answer, no. Question, if you got a person in the block who was supposed to be white, and that person was undesirable in the sense of untidy or something like that, you couldn't do anything about it. No, certainly we couldn't. And you would prefer that untidy white person to a Negro, no matter how educated or cultured. Answer, as long as they are white, I would prefer them. Question, no Negro, no matter how, whether he might be senator or congressman, it would not make any difference to you? It wouldn't make any difference. And even if the white man just came from jail, you would prefer him. Answer, because he is white and I am white. And that's kind of explains the mentality. Not to suggest that people who come from jail are undesirable or any of that, but I think you get the point in terms of the whole thing. Now, the area we know the most about today, and I really didn't know anything about this much coming up, was education. We know about Brown versus Board of Education. Now, Brown didn't reach Alabama for a very long time, because I graduated from high school in 1965. So that's 11 years after Brown. There were 10 kids in my family. I was the fourth. So Brown didn't reach Alabama until my youngest two brothers went to high school. That's how long it took. But to get to Brown was a long way itself. Never mind, it's a long way after Brown. So let me just say a little bit, and I'm not going to hold you very long, but let me just say a little bit about what led up to Brown. So these black lawyers were working on discrimination and segregation education. And they knew that it wasn't likely that they would overturn Plessy versus Ferguson. So they said, what strategy can we employ in the short run that will lead us to possibly at some point fully integrated society? So what they said was, look around us. Black facilities are grossly inferior. Black teacher salaries are substantially lower. There are no graduate or professional schools for blacks in most southern states. And so they said, well, given the difficulty of attacking separate but equal, let's go about applying, or arguing that the court should apply at least, not that they agree with it, but at least applying the separate but equal doctrine fairly. And so they left for another day the issue of whether separate facilities were inherently unequal. So where there were no graduate facilities, the argument was that blacks were entitled to enter the resources right now, to enter the school, white school in their state, and that they shouldn't have to wait. And also, they were entitled to go to the white school with no ruling on the issue of separate but equal, because there was nothing to compare the black institution to. What happened was some of the states, instead of allowing them to go into the white institutions, only a few did. I think Arkansas admitted blacks fairly early. They offered black scholarships to attend elsewhere. And so you find, for example, Fred Gray, who was Martin Luther King's lawyer and was involved in injunctions relative to the Selma Montgomery March, was a person who grew up in Alabama whose tuition was paid at Case Western Reserve University in Cleveland. Or Horace Ward, who became a federal district judge in Atlanta. They paid his way, Georgia paid his way to Northwestern. Or U.W. Clemens, who became a black judge in Alabama. They paid his way to Columbia University. And so that's how some of the states dealt with the notion that, there were no facilities for blacks at all. And so once they worked through those kinds of issues, then they sought to attack some others. In 1938, in a case called Missouri XRL Gaines, a black student refused a scholarship that was offered to go out of state and sued. His argument was, I live in this state. I'm entitled to a remedy here, so I'm entitled to go to the university here in Missouri. The Supreme Court held that the state itself had to provide the educational opportunity. In other words, they could not get rid of their obligation by paying for black students to go out of state. And then there's another case that came that same year called Scipio versus the Regents, University of Oklahoma. 1948. There, a black applicant was refused admission on the ground that she should have sued to establish a new law school for blacks. Or don't sue because you're not admitted to University of Oklahoma. Sue to have the state establish a black law school for blacks. That's all she would be entitled to. Supreme Court fortunately rejected this argument, saying she was entitled to her education at a state institution, and they were to provide it as soon as they would for other applicants. And then around that time, guess what Oklahoma did? They passed a law that black student programs could be given in separate classrooms or at separate times. Now, they did ignore, to their credit, this prohibition or this requirement at the law school. However, in the education school, things were a bit different. So again, another lawsuit. So they filed a lawsuit on behalf of a man named McLaurin, who had to sit in a classroom specified for color and had segregated tables in the cafeteria and the library. Supreme Court said the conditions under which he was required to receive his education deprived him of equal protection of the laws. And in a later case, Sweat versus Painter, Mr. Sweat argued that the hastily organized institution that was organized for blacks in Texas was inferior. But apart from that, that the educational experience and professional training for practicing law could not be achieved in a segregated environment. And this is the case where the Supreme Court ruled in his favor, and this eventually led to the court's holding in Brown that separate educational facilities are inherently unequal. Now, I know you didn't come here to get history lessons, and I really don't mean to bore you to tears, but I just want to give you some sense of the fact that even though we didn't know it, that there were lawyers who, while not fully accepted by their society and not even by their profession, were fighting hard, tough battles on behalf of the whole race and really on behalf of the Constitution itself. And I often like to refer to these black lawyers as the second founders. And I say that because there's no question that the job was unfinished by the original founders. They allowed for slavery to continue, the importation of slaves until I think 1808, and ultimately we had to fight a civil war over slavery. So these lawyers had to work through constitutional law to come up with theories. They did it at Howard Law School and used it as a laboratory, but they also did it through the NAACP in tandem with Howard Law School. I did not know about Fred Gray, the black lawyer in Alabama, and the fact that he was filing lawsuits in front of the famous judge Frank Johnson in regard to the Selma, from Selma to Montgomery March. I didn't know about that. But lawyers were there. They were paving the way. They were creating the circumstances so that when people protested, there would be a legal basis, at least to argue that they should prevail. Let me just say a little bit more about my thoughts about the legacy of African American lawyers in the quest for equality. I think that the model that was developed back at that time out of necessity of having essentially a public interest law firm or group work to try to address legal issues and bring about change set the stage for much broader use of that kind of device. I think that's one of the legacies of black lawyers. And now it's not unusual for us to see that not only other ethnic groups and women, but also advocacy on behalf of the elderly or advocacy in a wide range of areas. And that, I think, follows in tradition of those black lawyers who banded together to bring public interest lawsuits on behalf of African Americans. And I think that no question in my, I guess I shouldn't say I think, there's no question in my mind that one of the great benefits of their advocacy was they laid the foundation for not just themselves, but for the full realization of rights by other minorities, by the disabled, by women, because rights have been constricted in regard to all those groups. The argument was not just we, but all created equal and all have rights under the Equal Protection Clause of the Constitution, and we've accomplished much because of what they have done. I think you also could argue that in terms of law schools, that the Howard University Law School, in terms of being a laboratory, and let me explain what I mean by that. Those lawyers who were working on these constitutional cases would bring them before the students, and they would have the students work on them, and they would moot each other in regard to those issues, and then they would go forward. And I think, while it's not exactly the model necessarily of clinical education today, I do think that one can say that it's a precursor of clinical education as well. As I look at kind of where we are today in terms of the state of the black lawyer, there's some room for optimism, but there's also some room for concern. There's no question that we made some progress in regard to African Americans in the legal profession, and we made some progress in regard to other minority groups. But in terms of African Americans, that has kind of tailed off. I think African Americans constitute about 7% law school population, may not be exact, about something more than between 4 and 5% profession as a whole. There doesn't seem any great prospect if we look at the composition of law schools and nature of profession that would change drastically unless there is a comprehensive effort to make sure that African Americans are increased in the profession. I think there are a lot of good reasons for doing it. It's just plain right. We can't always keep arguing that it is possible in America that people can do something. We now are looking for probabilities. And so we have to be able to say more than you could possibly become a lawyer, but it is something that is within your grasp. I think African Americans, lawyers, the numbers need to be increased for a number of reasons. One is because I think, given the history of African Americans in America, that they have a special sensitivity to the need to continue to fight for the underdog and to continue to press for rights. That's not unique to African Americans, but I think you will find that in terms of the jobs they pursue, which are public interest and government jobs, that they have that. I'd like to see more African Americans in the large firms. We've not done very well in that regard. I think it's possible to be true to your calling, to be true to your race, to be true to your heritage, and at the same time do well in those firms. For example, I always tell African American students when I'm talking to them, if you go to a firm, you have to represent your client, but nobody says that you cannot advise your client. And if you have a Title VII situation or discrimination, of course you defend if you think your client has not discriminated. But if, in fact, and give them a good defense, I guess I shouldn't say what you think, but at the same time, part of the role is to advise them so that they will not, and that they actually embrace the principles that are part of America. So, again, let me conclude by saying that I think that the legacy of African American lawyer is tremendous in terms of equal rights, and the contribution to America is paramount. I do think that part of that legacy was also the NAACP Legal Defense Fund, which has continued to carry forward that legacy, and all the other things that I mentioned here today. It's been my absolute pleasure to be here to talk to you tonight, to try to combine two things. One is to talk about African American history during African American History Week, month, and at the same time bring you some sense of those African American lawyers who sacrificed so much so that they could bring down the barriers of segregation and make this more just and fair society for us all. So thank you very much. It's the pleasure's been all mine.
That was an excellent discussion. The judge has offered to take some questions. Don't be shy. Professor Artucio?
Well, I'm not sure I'm the best one to explain that. but I've observed what you say. For example, many of the state flags are designed so they look essentially like the Confederate flag. It reminds me when I was in college, my first year, I started at a predominantly black college in Birmingham, Miles College, before I transferred to a college later in Ohio. And I was had a job with the Postal Service 20 hours a week as a student. And I remember picking up a postcard when I was at the rock box, go around and get the letters from boxes and take them back to the post office. And I just remember this quote. Maybe I shouldn't be reading people's postcards. But it's like, and tell auntie, the South gonna rise again. I remember that. I don't know. Many things have changed, but there are some things coming back now, and so I do worry that that it's scary that in some places, I think racism is as alive as it ever was, and that does bother me. So when I say we made a lot of progress, I mean, we can't deny that. I see two of my law school classmates here, and certainly I think they would agree. We were kind of the first group of African-American students where they had a sizable number in law school. Of course, the numbers have, grown a lot since that time. So we made a lot of progress, but there's just a lot of racism still around. It's not all located in Alabama and Mississippi either. There's just pockets, apart from inadvertent racism, and that there are just pockets of bad places that you have to avoid. But I wish I could answer your question. I mean, it baffles me. It baffles me. Yes. Yes. Well, sisters and brothers, you want to know about my sisters and brothers first, right? It's easier to answer. So, I have 5 brothers and 4 sisters, all went to college, some with graduate degrees. I have one brother who's a lawyer. He's in Atlanta. And so, my parents didn't have a college education, but they were insistent that on the fact that we would. And so that came all right from their standpoint. What do we do now? I'm not sure I have answers for that. We know that I think the fundamental problem we have in America is that we're kind of stuck, and I don't know how we work our way out of it. I think there are a lot of things we can try to do, but I mean in terms of dramatic things. The Supreme Court says, of course, you can't rely on societal discrimination to address historical racism in America. And yet we know that some of the problems that we face in America have existed for generation upon generation because they just kind of build on the fact of inequality and discrimination for so many years. And so that doesn't appear to be a root. I think also, candidly, what happens is after so many years, people are just not tuned to what happened historically. They're saying, but I'm here now, don't blame me. I think that's a problem. The other thing is we have, candidly, also people coming from, and with rightly so, with high expectations from different countries around the world who are not part of that history. That is not a put down at all, but we've got now a different world. And so the question is kind of how, we got a lot of problems to deal with. I mean, Hispanics certainly, are very underrepresented in America, and they're not the only ones, and blacks are not. But it's just a range of issues. I think other than kind of all the institutions that we have, we're talking about redoubling our efforts to make it a priority, to increase representation of minorities. I think we're going to have a problem. We're up about 25% of the law school population, all minorities. The African American numbers have moved hardly at all in recent years. And of course we know that very shortly, not in too many years, minorities are going to be the majority of the population. And so we look like we're going to continue to have professions where minorities are a really very small percentage. I think that's going to be a problem as we move forward in a lot of ways. I mean, one, it's right to do something better, but two, I think it's just not going to, it's going to cause a lot of concern and over time, and a lot of problems, I think. I don't have an answer for that. Perhaps if you have some thoughts on it, I certainly would be, I'd be happy to hear them, but I really don't have an answer. Wish I did. There are probably some people here who have, and I think that have spent their time at least trying to address that, and I think Toro, I just think you have to work where you are, and right now we're at Toro, and so I think Toro, which I know you have a diverse student body, but Toro has to work with Toro, I guess, in a limited sense, to make sure that it's doing everything it can to produce a student body that's reflective of America and to some extent the world. Yes.
Okay. So he spoke about Brown versus Board of Education and how, it was a very thought out process, by the lawyers behind it. And he also mentioned that some of the civil rights attorneys back then were maybe not fans of the techniques that, for example, Dr. Martin Luther King, the protests and, kind of making, I guess not going about it in the legal sense, just trying to make,
Right.
make your thoughts known. So my question is, do you think that that kind of protest is equally necessary alongside the legal process, or do you think?
I do in this sense. I mean, I don't know, I have to know what protests and what, but I just think in general, when you're young, and you're idealistic, you ought to do something about it. It doesn't necessarily mean you've got to protest. I'm not saying that, but I'd be surprised if you were young, idealistic, if you didn't make your voice heard in some kind of way. There was just a lot of disagreement about how we should proceed in regard to African American rights at that time. Some people thought that Martin Luther King was too conservative after the protests and all that, and they were pushing him to do much more. And so there were, young militants at that time. There were some people saying he did too much, and some said he did too little. We had Malcolm X, we had Rap Brown, we had just a whole range of heroes. So a lot of those lawyers, I guess, in one sense, were maybe conservative in terms of conservative backgrounds. I mean, Hastie and Houston, they certainly were not against protest. I know that based on historically, but those were guys who were at the cream of the cream. There used to be the notion, and it's hard for people to believe, but and some think it's still a notion today, but it was definitely a notion back then, that you had to be better in order to have any chance at all. And that's what you saw in people like Houston and Hastie. And then there was also William Coleman, who was after them, but who went to Penn and to Harvard and the Harvard Law Review, and the first black clerk for Frankfurter. And all those people were involved in putting the legal strategy together for Brown. I can't say that some of them did not like the fact that Martin Luther King was leading marches, or that they sometimes thought, if you saw Selma, that he was leading people in harm's way, and that a lot of people were going to be brutalized and killed and die. And so that's part of it. But certainly there were lawyers there who defended them, who went in for injunctions. And certainly there was protest in D.C. way back in the 30s that Hastie and Houston worked to defend, protesters back at that time in the labor area. So it was a mix. I don't think there was any way you can say that there was kind of an orthodox or one position on that. Yes?
Let me bring you the microphone. And we'll make this the last question.
Good evening, Judge. My name is Stephanie. It's really a comment adding on to the maybe reasons behind the lack of, we could say, diversity or increase with African Americans being lawyers. Again, I'm Stephanie. I'm actually from Jamaica, and I moved there when I was 15, a couple years ago, I think. And I went through the high school system here. It wasn't the best. It was in Brooklyn, in Crown Heights. So if you know Crown Heights, it's not the best at all to go to high school. And what I noticed there was, though, the teachers, even the principal, I don't think they cared that much about the students, like what we really did. I think they just wanted us to pass exams to get out of high school, just to say we got a high school diploma. That motivation wasn't there. When I made it to Hunter College, that's where I went to undergrad, my advisor, I just noticed that it was somewhat institutionalized, where they kind of don't consider nursing. They try to steer you away from, if you say, I'm interested in law, et cetera, and they're like, okay, take the prerequisites there, but consider nursing, or do you play a sport? Or, the emphasis for us, for those who identify as African Americans, is either body capital, boxing, running, basketball, or the medical field, nursing assistant, not even doctor, forget it. It's either nursing or become a CNA. And, so I think for me, it starts there within the educational system where, depending on where you go to school, more than likely, depending on the neighborhood you live in, you will see advertisements on TV that are geared towards, us, but it's
Yeah.
not in the highest profession. It's,
I think you make a good point. You remind me that the effort both has to be in the educational system in general, so that it is a stronger and better system for minorities. Also, apart from that, are the efforts of law schools and bar associations and people in the profession. So they have to go hand in hand, and the issue is not going to be solved overnight. But you're right that the educational system is fundamental, and we've got to make sure that we prepare people and also support them in ways that give them the confidence that they can do whatever it is they want to do. And so you're absolutely right. The educational system is fundamental. All right. Let me just recognize two of my dear classmates from NYU, class of 72. They were kind enough to come here and join me tonight, and I appreciate that very much. So Judge Antonio Branveen, will you stand up, please? And Attorney Ronald Travis. What? Well, you be young tonight. Thank you.
One more presentation. First, I would like to thank the judge for being with us, and I would like to recognize and ask Professor Post to come up, because it was her idea a year ago to bring Judge Oliver here. So could you please come up and help me give the judge our presentation? We have a silver bowl that says Toro College, Jacob D. Fuchsberg Law Center, Distinguished Jurist in Residence, Chief Judge Solomon Oliver Jr., February 11, 2015. Thank you all for coming.